right, thank you everyone for joining us today. My name is Dustin Saldarriaga and I am an associate at Scott Legal PC. We're going to spend some time today talking about the National Interest Waiver, or NIW, green card. This is an underutilized green card category and one that we've started to see more and more people pursue, especially among those who are applying for a green card as entrepreneurs. A few things before we get started. Our firm is a full-service immigration law firm, and we represent clients who are pursuing various types of visas, both family-based or employment-based, and of course, including the National Interest Waiver category that we'll be talking about today. This webinar is part of a series, and we'll be continuing the series by doing at least 2 webinars a month. These will be on a variety of different immigration topics. We already have a number of webinars scheduled, and we'll be adding more regularly, so please do check in occasionally to see what else we've added. Also, at the end of this webinar, we'll be sending out a few things to all of the participants today. First, we'll be sending the PowerPoint presentation that you'll see on your screen. We'll also send a link to the recording for this webinar. The webinar is being recorded. We'll also be sending a comprehensive guide about the EB-2 National Interest Waiver visa. And finally, we'll be sending a link where you can sign up for our additional webinars. And I should also add, the email that you get will also have a link to our YouTube channel. We post our webinars to our YouTube channel, as well as shorter videos on a range of immigration topics. So check out our YouTube channel if you have any questions at all or want to learn more about the options we talk about. A few housekeeping items before we get started. We do plan to save a few minutes at the end of the presentation for questions, but please do send those in as they come to your mind during the presentation. You can do so by either messaging me through the chat box or by using the Q&A function on Zoom. So again, please don't hesitate to send those in during the presentation, and I will share them with our presenter today. Again, my name is Dustin Saldarriaga, and I will be the moderator. We are very fortunate to have Ian Scott here today to speak with us on this topic. Ian founded Scott Legal a decade ago, and he has a vast amount of experience processing the National Interest Waiver visas, as well as E2 visas, family-based visas, and the full range of options that our firm provides. Without further ado, Ian, I will go ahead and pass things off to you.
Thank you very much. Thank you very much, Dustin. And the National Interest Waiver, it really is a great green card option, and one I think that in the past was one that we didn't see that often. And the reason we didn't see it that often is because before 2017, it was a very, very difficult green card to get. And the reason was that the standard with respect to this particular green card was governed by a case that was, someone applied for the green card, it was denied, and then the case went to an appeals board, and then the appeals board defined exactly how these cases should be adjudicated. And but then in 2016, at the end of 2016, that particular case changed, because it happened yet again where someone applied for a national interest waiver, it was denied, and that particular client's name was Danisar, and it's a public record, and that that particular case went through the process where the appeals board redefined the standard and opened up the standard considerably, so that they made this a particular category that was much more attractive to more individuals. And in particular, it opened up the standard to entrepreneurs, because before we wouldn't really have thought of doing a national interest waiver for an entrepreneur, but the Danisar case has certainly made that possible. So, what is a national interest waiver? So before we jump into the 3 requirements that case defines, let's talk about some threshold issues or threshold requirements. So the national interest waiver falls under the EB-2 category. So for all of the employment-based green cards, they are listed from categories EB-1 through EB-5. So EB-1 is extraordinary ability, and EB-2 is broken down into 2 different categories. So one is a category where an employer is sponsoring you for a green card, as a professional, and the other is national interest waiver. But regardless of which category you're in, category 1 or 2, you have to meet the threshold requirement first. And the threshold requirement is that you must have either an advanced degree or its equivalent. So an advanced degree is a master's degree or higher. So if you're a lawyer, you would qualify because you have either a JD or an LLM. If you have an MBA, you would qualify. So any master's degree, and it doesn't have to be a master's degree from the US, but the equivalent of a master's degree, or a bachelor's degree with the equivalent of 5 years progressive work experience in the profession. So that if you have a master's degree or you have a bachelor's degree plus 5 years progressive experience, then you've met the threshold requirement. But let's say you're an individual that you went to high school, right? When you went to high school and you didn't have a bachelor's degree, you didn't have a master's degree, so that takes you out of qualifying for this threshold requirement based on the either advanced degree or its equivalent. Let's say you have an associate's degree or something like that. It takes you out of the so instead of the government saying that you're not able to apply for a national interest waiver, they give you one other test that you can utilize, and that is you can show that you have exceptional ability in sciences, arts, or business. And it's a test that really determines whether or not you have this exceptional ability. And really what you have to do is meet one of the 7 criteria listed below. So I'm not going to go through all of the 7 criteria that are listed there, but they are listed there. And if you meet 3 of those, then instead of qualifying under advanced degree or its equivalent, then you can qualify under exceptional ability. And this exceptional ability is very different from the extraordinary ability in EB1 category. But as I said, if you take a look at the 7 categories there, then it's almost like, after you meet this threshold requirement, then you can move to step 2. And step 2 is really what's defined in the Danisar case. And when we look at step 2, what we're really talking about here is we're talking about the individual showing that they have a proposed endeavor that has substantial merit and national importance. So when we think about this first prong, we're thinking about this prong independent of any individual. So this is all about what is the proposal, what is the endeavor, what is the applicant going to do. And when we look at what that applicant is going to do, we ask the question of whether or not it has substantial merit or national importance. And so it could be that someone is developing a particular type of technology. It could be that the person is a cybersecurity, the person is going to be offering services in cybersecurity that the government finds important. It could be that the person is going to be offering the government consultation or advice on counterterrorism activities. And all those examples I'm using are examples where we actually have done a national interest waiver case for those particular examples. But when you're looking at prong one, you're looking independent. You're separating out what it is that's going to be done, and then asking the question of whether or not the government's going to find that important. And we're going to talk about some of the things that you would look at to assess whether or not the government would find that that's important. Now, after you have looked at the endeavor, now we move to the individual. This is the person that's applying for the national interest waiver. We move to the individual and then we have to look at the assessment of, well, is the person well positioned to advance the proposed endeavor? So for this, we're going to look at the person's track record. Have they done it before? What's their education? What's their work experience? How far along is the endeavor? Do they have funding? Are other people interested? How likely is it going to be to succeed? So some of the same things that we may, kind of include when we're looking at EB5 or E2 petition with respect to the viability, or even an international entrepreneur rule if we're trying to apply under, some type of benefit. We're going to look here to see, is the person going to be able to do what they say that they're going to do? And this is a difficult prong. It's not a simple one. It's not as simple as just providing the government with a business plan and that's the end of it. here they really are going to want to see that you have interest. Maybe you have patents, maybe you have people that have already expressed interest, maybe you have contracts already signed. So they're really going to look to see how far along you are with the endeavor and whether or not you're going to be able to pull it off. And then the final thing is they're going to look at showing on balance whether or not it's beneficial to the United States to waive the labor certification process. And what that is when you're looking under the EB2 and EB3 categories, other than national interest waiver, companies can sponsor people for green cards. And when they do sponsor them for a green card, they have to show that that they can't find a qualified U.S. worker. And it's a process called the labor certification process, or PERM. And so what the case is saying is that you have to provide documentation to show that the government should waive that, because it's in the government's interest, it's in their national interest to make sure that U.S. workers get jobs. So this particular criteria is looking at, well, why is it that we should waive that? And some of the things that you may look at here, you may look at the individual, you may look at the extraordinary ability of the individual. You also may look at the person's track record and their past experience and accomplishments, because in essence you're saying on balance this person is worthy of a green card. But then also you may even be going back to some of the same arguments related to why this particular matter or endeavor is actually important. One kind of interesting thing here when you look at entrepreneurs is that entrepreneurs are not eligible. Like if you own over 50% of the company, you're not eligible to apply for the labor certification process. So even that often, even on its own, is one of the reasons that we typically cite when we're looking at the third prong, when the individual is seeking this particular category and is also an entrepreneur. So, I think that a few things that really made it easier, made Danisar kind of a change from the case that used to decide national interest waivers. One is that when the old case really used to, whatever your endeavor was, it had to really have a national scope. So if you were setting up something in a particular state, for example, then that in itself would could disqualify you, because the adjudicators would say that the scope is not broad enough. Whereas Danisar explicitly said that geographic location or area is can be important, but you can have things that are nationally important even if they are limited to one one particular area. So for example, you could have a concept where, or you could look at the concept of providing employment to marginalized groups, or providing employment to groups that are in economically depressed areas. And it could just be one economically depressed area, and that could still satisfy this Danisar standard. The second prong, I had already talked about that with respect to when we're looking at the third prong, so I won't spend more time going through that. And the other kind of very important thing with Danisar is that although the second prong does focus or does look at the applicant's ability to advance the endeavor, Danisar or NIW can be approved on plans. It doesn't have to, it doesn't have to be, the business, like a business, for example, doesn't have to be up and running. And really the question of the ultimate success can be demonstrated even if even if it is a planned venture. So I think it's something to always keep in mind when you're looking at this, is that you do have to satisfy prong number 2, but we're going to see from one of the examples that we go through in this presentation how the applicant was able to satisfy prong number 2 even though the business had was kind of on the brink of starting. So, now we're looking at timing considerations and other considerations, and often when people are looking at an NIW, they're moving from, one particular visa to NIW. We do a lot of E2s to NIW. Sometimes people do an O1 to an NIW, but a lot of the time they have a non-immigrant visa and then they're moving to a green card. So one thing to keep in mind with national interest waivers, unfortunately, there's no premium processing available. So it could take a year for them to adjudicate your national interest waiver petition. And when you are filing a national interest waiver petition, you're filing an I-140 petition, and again under the EB2 category. So when you file an I-140 petition, for most countries under EB2, you also can file an I-485 petition. So that with an I-485, you can apply for work authorization, travel authorization. But I think that the strategy related to how you apply and whether you file an I-485 will really depend on the strength of your case. And because you don't want this, if your case is borderline, then perhaps you just want to file the I-140, because if you don't, it could impact, kind of renewing your visa in the future, because most of the time the people will be in the US on some visa that is not a dual intent visa, like the ones listed there, like TN, E2, et cetera. None of those are dual intent visas. So it could make renewing them more difficult if you're, if either it's denied, but certainly if your I-485 is denied, and your I-485 would be denied automatically if your I-140 was not approved. So we talked about the application process. You submit the I-140. Then, if you're not planning on doing adjustment of status, and you can consular process. And lots of people do this because they don't want to be stuck in the country for 8 months. Because if you file an I-485, you do have to remain in the country until your work and travel authorization gets approved. And sometimes that can take a year. So you wouldn't be able to travel during that time. Whereas if you did consular processing and you had some underlying status that allowed you to re-enter, you could certainly do that. And in terms of I think that whether someone chooses to adjust status or do consular processing, it really is going to be dependent on their situation. If they are in the US, they don't mind traveling for that period of time that it takes to get the adjustment of status, work authorization or travel authorization, then that's certainly a great option. With adjustment of status, you do have to pay attention to when you file as well. If you just entered the country and you immediately, months after you enter, you file for an adjustment of status, that that can be a problem. So that's something to take a look at. But yeah, and consular processing, it could be just that you want that flexibility, and or you're outside of the country at the time. So, what do you submit when you're in when you're filing this petition? So, first we talked about the threshold requirements. So, they don't, the government doesn't just take your word for it. They want evidence. So, if you have an advanced degree, you have to submit a copy of your master's degree. If your degree is not from the US, then you have to do an equivalency that says that your degree is equivalent to a master's degree. Similarly, with the bachelor's degree, if it's not in the US, you have to submit something that says that it's equivalent. Will often include transcripts as well. With your prior work experience, they don't just take your resume and say that, well, your resume says that you have this work experience. You would have to get letters from previous employers detailing the work experience. And the wording in the statute is that it's progressive work experience. So it's really saying that you're taking on, more and more duties as time progresses. So those letters are really important. Ultimately, if you can just qualify under the master's degree, that's great. But this is something that you would submit. Now, if you're qualifying under the exceptional ability criteria, then you have to produce evidence of the three criteria that you meet. So one of them is that you have 10 years of experience, for example. So again, that would be employment letters. One of them is memberships. Again, that would be, documentation of those memberships. One of them is, I believe, another type of degree like diploma or associate's degree and things like that. You would have to produce evidence of those types of degrees to, and that's the first part of the petition, just showing that you are able to move on to the next the next part. So now, for the different prongs, to the extent that you're trying to prove that the substantial merit of the endeavor or national importance, you could look at newspaper articles, you could look at reports, government published data, anything that you can find on the internet that is from a reputable source. But also you can go to journals, you can go to, different sources where where they may talk about statistics or talk about why this government or particular government would find the endeavor important, and quote that. We also would include documentation here related to experts. So experts can write about why something's important. So you would describe that, the expert would describe who they are and why they're in a position to give that particular type of opinion, and why it is that the government finds it important. You can also go to sometimes the government's own websites. Recently the government produced documentation that supported people in certain fields, in STEM fields, science, technology, engineering, and math, that they said that those particular professions are important to them. And so sometimes you can go to the government's own pronouncements and see what they find important, and use that in your petitions. You can also get letters from Congress people that describe national importance as well. A lot of the time, if you're trying to qualify based on economic benefit, you definitely would want an economist report. So economic benefit in terms of job creation, and those would be paid reports, right? They're not reports you'd write yourself, and an economist is not going to write it for free. So you'd pay, they're paid reports where you give them your business plan, give them details, and they would provide information related to the economic benefit of your endeavor. In terms of showing your own background, resume, degrees, it could be letters related to your work experience. But usually if we're saying the person's well positioned and we're including an expert letter for that, we're including expert letters from other people who are really important in the field, in the area, talking about this particular individual and why they're going to be successful. Maybe it could be awards that they've received, patents that they've engineered, the fact that people call them to speak at conferences, etc. Anything that really shows the history of their success. It could be contracts that have already been signed. It could be investors that are investing in the enterprise, that those particular people show that like, especially if the investors are accredited investors, or investors that have a track record of picking winners. That's something that's going to, something could be very helpful for your case to prove prong two. Some of these other things we included: evidence of contracts, letters of intent, and that you have the capital that's required to ultimately succeed. So those are but they're, one of the things with NIWs, they're not cookie cutter petitions. They're very structured, very kind of strategic, and very well thought out in terms of what it is we decide to submit. So let's take a look at a case study for an entrepreneur. So this is an actual case, right? So this is one of these cases where the person submitted a petition and the petition was denied, and then the person appealed, and then the Board of Appeals said, yes, this person is absolutely eligible. So this was an individual who started a small consulting firm to work on projects with US vets, and the premise was that the vets go away, they have combat, see a lot of things, come back, and it have difficulty integrating into society. So it's very obvious that that happens, right? And I think that, if you listen to the news, you always hear that, etc. However, something that is obvious, is not necessarily obvious to the US government. Keep in mind, this was denied the first time. So but what was when the Board of Immigration Appeals commented on this case, they said, well, they submitted expert opinion letters, news and media research reports, and all of those documents supported what they were saying, that returning vets have a difficult time, and providing services to those vets is substantial merit. And then you can go from that that if you provide them these services, then they can better integrate into society, that there's economic benefit associated with that, and that it's the right thing to do, given that the people were serving their country. So those are all arguments that the government ultimately found compelling enough to approve the case. So the person, in terms of them being well positioned to advance the endeavor here, because keep in mind, first the first is just looking at, is what the person proposing, is that in the national interest, right? So now we're looking at the actual individual. So this particular individual happened to be a vet, right? So argument is that he knew firsthand what it was like to come back. So it was in a good position to do it. But also the more compelling reason that the person got over this prong is because the person had kind of prior success, like he got letters saying, attesting to his prior success working with vets, and then also he had emails and letters from prospective clients confirming their interest in working. And then I believe in this case that he also had kind of letters from government agencies that indicated that they would kind of refer people to this organization. And keep in mind, this wasn't a huge company, right? This wasn't Facebook or something like that, right? This was a small endeavor that the person was starting. And then on balance, the waiving the requirements of the job certification. I think here's where they kind of opened up to this particular case is a good case for entrepreneurs, where they kind of opened up the whole kind of idea that it would be impractical for this person to obtain labor certification because it's his own business. And then but we don't ever just leave it at that. We kind of also say, and the value of the services on the person is offering, on balance, that is beneficial, and as a result of that they should waive the labor certification.
Great, so thank you, Ian. Actually, we have arrived at our question and answer portion. We have not received any questions. If there are any last minute questions that anyone has, please go ahead and share them. But in the meantime, I will take a moment to remind everyone that this presentation will be recorded, and we'll be following up with you to share the recording, as well as links to our future webinars and the presentation that you saw. So Ian, I'll go ahead and thank you for taking the time to share your experience. Again, if anyone wants to reach out to us directly to speak about your specific circumstances, please do contact us through our firm. It's very easy to set up a consultation. Okay, we do have a question, Ian.
One question.
Is it possible to apply for a national interest waiver while being on an E2 visa?
So the answer is yes, absolutely. So I'd say that one of the primary ways that we're moving people from E2 to a green card is under a national interest waiver. I'd say we, probably have, like over 10 active cases that we're working on right now, where people are moving from E2 to national interest waiver, and I think that it's a great green card option. So absolutely, if you meet the criteria that we identified in the presentation, then it definitely is a great option. And often, a lot of the times, we just had a meeting with one of our clients who's an E2 client, and initially when we started the meeting, we thought it was going to be national interest waiver. And interesting. I want to talk about this particular case because I think it's a bit interesting in terms of what often, comes up. So this was a client, he's doing E2, and he founded a company, and the company was providing for just to keep it anonymous, the company was providing scientific services, right? So that the US government would find very appealing, right? Some of them had to do with COVID and other different things. So, but this guy was not the scientist, right? He was the one who started the company, but he was not the scientist, right? Now, when we talked about the national interest waiver, I still think that he's eligible, qualified, and definitely a very good candidate for national interest waiver. But just to illustrate the prongs, right? So the first prong was a slam dunk. The endeavor that they were talking about, absent the individual, the endeavor was absolutely clearly in the national interest. I think that was not a problem. The issue that this particular client might have, though, is in the second prong, that they're well positioned to advance the endeavor, because the government could conclude that he's not necessary, right? Because at this point, the person only owned 30% of the company. and the person wasn't the scientist, versus if the person was actually the scientist, then proving that second prong would have been a lot easier, right? And again, I do think that I do think that this was it's going to be a strong case, but you know, whenever we go over a case, we have to point out what the weakness. We don't want the first time a client here's what the weaknesses are when they show up on an RFE. So we do point them out, but so I think very doable. But then the other thing I wanted to point out about that particular case is that, during the call, it was very clear that the person was eligible for EB1 extraordinary ability as well. And I think that the EB1 is actually a bit clearer case for this client. So because the EB1 is all about the individual. That's not so much, it's not at all about the endeavor. It's all about the individual and looking at their accomplishments. But but it's also a lot more, the EB1 is less strategic because it's much more specific. You have to meet 3 of the 8 criteria. So it was kind of easy for him to check boxes on those 3, at least 3. I think he probably met 4 or 5, but but the point is that sometimes people apply for multiple at the same time.
Perfect.
Multiple
Thank you.
cards.
Perfect. And similar question. A few have rolled in while you were answering the first. Can I file under the EB2 category and another category simultaneously?
Yes, no problem at all. So we have a individual that we did an EB. This is another one of our E2 clients. We did an EB5 direct investment for her, which was just approved a couple of months ago. We also filed, or we're in the process of filing, a national interest waiver because she has a very strong national interest waiver case. And now she has the EB5 direct investment approval, but EB5 has a lot of other requirements. You have to go back in 2 years and prove that you've hired 10 full-time workers. So she's still going to go ahead with the national interest waiver and try and get that approved. But you can apply as many green card categories as you want, and the one that you get first, you can keep.
Perfect. And that includes family-based categories as well.
That's right. That's
Perfect.
right.
Yeah. Okay. I am currently on an F1 student visa. Can you say more about the difficulty of extending that visa status if I've also applied for an EB2 NIW?
Yeah, absolutely. So the F1 is a non-immigrant visa, and in order to get non-immigrant visas approved or renewed, you have to, if they're not dual intent visas, you have to show that you have ties to your home country and you don't plan on, adjusting status in the US. So if you have an NIW petition pending, it's a green card petition that you have pending. So the government could, conclude that you don't have that you do in fact have immigrant intent, and as a result of that not renew your actual visa. That's why you always want to plan well in advance so that your petition is going to be approved before you have to renew any non-immigrant visa that's not a dual intent. So the only dual intent visas are O's, L's, and H-1Bs.
Perfect. And this participant says, if I hold a master's degree, then their understanding is they do not need to meet 3 out of the 7 criteria. Is that right?
Yeah, it is a great question, and it's one that comes up all the time and the reason it comes up all the time is because the way that, I'm not sure if they've changed it, but I don't understand why it looks like this, but the way that the USCIS describes this on their website is very confusing. But it's absolutely correct. If it's either master's degree or bachelor's degree plus 5-year experience, or exceptional ability, 3 of the criteria. You only need to meet one of them, and then you can move to the next one.
Perfect. And then Arthur has a question about reviewing the CV and seeing if he's eligible. Arthur, I would encourage you to schedule a consultation. We do on our website offer 30-minute consultations, very straightforward and simple, and that would definitely be the best way for us to give you detailed and advice that's catered to your situation. Great. So we don't have any other questions. Ian, I want to thank you for taking the time and sharing your expertise. And participants, those of you who are with us today, thank you for taking the time to join us. Please be on the lookout for our follow-up email and the information that's in it. And we do hope to see you on future webinars. Thank you so much.
Perfect. Thank you. Thank you very much, Dustin. Thank you everyone for joining. Bye-bye.